We are seeing a lot of fights over religious liberty play out with currently a amendment voted down by, or it's not voted down, it's stalled, or was it voted down? Let me make sure I get the verbiage right here. Yes, the Democrats blocked, I should say. They blocked an amendment for the Respect for Marriage Act that would add additional protection for religious institutions and for effectively religious belief to not be engaged in compelled speech or to violate core principles and tenets of their beliefs. So that's going on right now. I mean, in the background of what we're about to tell you here on the legal side, there is this Respect for Marriage Act that is supposed to be a codification of Obergefell, the Supreme Court decision that then declared that same-sex marriage was constitutional. And here we are now seeing this play out through the legislature. Well, you also have this case that was heard yesterday. It's very interesting, and we'll try to break it down into ways that doesn't get a little too in the weeds on the legal side. But it really does, I think, matter as well and tells us where all of this is going when it comes to the First Amendment, particularly as it pertains to speech, but also free exercise of religion and religious freedom. So you have this case, Clay, 303 Creative LLC versus Elenis. I think I read this. I did not listen to the oral arguments. I read the transcript of it. And here's what is at issue. You had in Colorado, once again, Colorado, just like Masterpiece Cake Shop.
This is an outgrowth of that case. They are connected. So yes. For people out there who remember the cake baking case, this is the next evolution of that.
So the central dispute here is public accommodations law versus compelled speech. And what happened was a 303 Creative is a company that builds websites. Web designer Lori Smith has this studio, 303 Creative. They make websites for weddings. I've been to enough weddings to see this. You know, it's like, you know, Bob and Tammy are getting married, and like, here's their registry, and here's the information, and that kind of stuff. So Lori Smith wanted 303 Creative LLC, Limited Liability Corporation, to be able to put on her website preemptively that she didn't want. This was just argued yesterday at the Supreme Court. I will say that even in the transcript, it comes across that Justices Jackson and Sotomayor are ferociously hostile toward this position that has been taken here, and just in general. I mean, for them, there is no anybody who doesn't see gay marriage, same-sex marriage, heterosexual traditional marriage as all the same. They view as a bigot along the lines of somebody who opposes interracial marriage, for example. They see no distinction. The justices, I think, those two justices make that very clear in their view of it. But, Clay, this Lori Smith wants to put on her website that she will not create websites for the weddings of same-sex couples ahead of time, and then link to, here are some other great web designers that will do this for you. And so she's bringing the case because she wants to know whether this is legal or not under the Colorado statutes that apply. And what I think was really interesting was the back and forth over both sides agree that providing chairs, providing, sandwiches, a number of things, provision of basic services you can't discriminate whether or not you're going to sell chairs to somebody's wedding because you don't agree with the wedding. But is it speech to create a website that will talk about a wedding? And there was a lot of back and forth over this one. And there's a big takeaway we can get into here, but this is the legal weeds, Clay. What did you find in them?
I love this case. Okay, so the lawyer in me, when you are, this is like a law school hypothetical. So most lawyers, if you're interested in law school at all, the way that you get your grade is an end of the semester exam, most of the time. And that end of the semester exam will give you an unsettled, oftentimes, legal hypothetical that you have to analyze as if you are a lawyer. And, Buck, this reads like a legal hypothetical question. To me, as I work through it and think about this from a judge perspective, what the distinction here has to be made is between unique talent versus generalized work. And let me explain that in a little bit more of a concrete fashion. So, Buck, you and I will sometimes give speeches, right? We'll be paid, we'll go to different parts of the country, and we'll speak to groups. We are available to be booked on websites. Typically, speakers are. But we don't accept every single opportunity. Maybe it's because the schedule is booked. That's typically for me. Or I don't want to go to that part of the country because I've got a kids event that I'm going to try to be at. There's all different sorts of reasons why. And then sometimes maybe, although it depends, but I don't believe I've done this, because you don't agree with the group that wants you to speak. We aren't compelled to take those offers. Similarly, if you are a musician and you have maybe sometimes you play weddings, you don't have to accept every wedding offering. So to me, what unites here for the cake and also the website is the question of, are they creating a unique enough experience? Is the cake tailored and created in such a unique way?
Well, now it's website.
And now it's a website, right? And they kind of dodged the question on the cake, right? They kind of punted on what exactly, I think they procedurally decided that case.
So the way that went down, as I understand it, and it was 6-3. Keep in mind, Colorado, federal circuit court in Colorado and then appeals court in Colorado, I guess it was the Ninth Circuit, ruled against the Masterpiece Cake Shop and owner. And then eventually the Supreme Court came down 6-3 in his favor. But a lot of people point out, Clay, that outcome, years of, first of all, getting
litigation,
what would seem to be the wrong constitutional outcome twice from federal courts, first circuit, then appeals, and then having to go to the Supreme Court. The process is the punishment at some level.
Yes.
And they haven't stopped, and people don't even really know about this or should know more about it. Then the activists, the sort of LGBTQ plus more extreme activists even started showing up, and they wanted him to make, Satan cakes, and they're really just trying to constantly harass this guy. In this instance, she's claiming that the creation of the website is a creative act because of what she puts into it and everything else. So if there was an off-the-shelf website, she could, because that was the cake holding was, if you have like a cake, let's say you got a lemon meringue, well, that's a pie. You've got a chocolate strawberry frosted cake. The Masterpiece Cake Shop has to sell it to a gay couple, for example, but they can't make him write on it, congratulations on your wedding, Bob and Bill or whatever. That was essentially.
By the way, this also would apply, Buck, and I think it's interesting. To me, it's the distinction between if there is a unique creative element that you are bringing to bear as a part of the production of your content, then you can make choices about whom you decide to work for. If you are, for instance, just doing, like your point there, think about it, if you're out there like me and you go into we buy a lot of ice cream cakes, right, for kids, because the kids love ice cream cakes for birthdays. They have a lot of the ice cream cakes already prepared, and it might say generically on it, happy birthday. And you can just go take that out of the counter, you take it up, you buy it. It doesn't have any specified uniqueness to it. You should have to sell that, right? Congratulations on your wedding. It's a generic cake that's already available in your store. As soon as you are saying, I want this particular message written on it or a specific design for that cake, to me, that's a unique talent. And that's that to me is the distinguishing factor.
Right, that's the creative process that they found was a distinguishing. The same way that they can't have you write "there is no God," for example, on a cake or something like that. That's the compelled speech doctrine. So you have compelled speech versus public accommodations, which is you can't say my restaurant will only serve Asian people. That's illegal, right? Or I will only rent my home to people of Samoan ancestry or whatever it may be. You can't do that. So now when you get into, okay, can you preemptively exclude a protected characteristic from your creative services and claim that the creative services are website design? It's getting pretty deep into the, and even I could tell the conservative, I think they're going to find 6-3 in favor of 303. I do believe that. We will see. We'll find out this spring. But you could tell they were kind of like, well, but is it really a creative process? There was a lot of poking around on that issue. But Clay, I think the bigger takeaway from this, and this is why it's interesting that so far the additional protection from the Respect for Marriage Act, the protection for religious belief, there is the activist wing within the LGBTQ plus agenda will not be satisfied until essentially there will be lawsuits against Catholic churches for not. I mean, it's going all the way. There's not going to be some détente. There's not going to be, okay, fine. There will be activists. There will be left-wing agenda that continues to say, I'm sorry, but the fact that the Catholic Church, this is their position now, just to be clear, but their position is the fact the Catholic Church won't perform same-sex weddings is unconstitutional and is bigoted, and they will not stop. I think that's what everybody should be prepared for. The ultimate plan here is to sue Christian churches, particularly Christian religious institutions, into submission over time until they bend the knee. And it's not just going to be on same-sex weddings, by the way. It's going to be on a whole range of issues. But this is, I think, the next frontier legally, and this is what you're seeing continue to play out.
And here's, Buck, what I would say. This is the lawyer in me kind of hypothetically thinking forward. What if the website designer had said, I won't, and I think they discussed this some, I won't make websites for interracial marriages. I won't make websites for anyone other than Asian people who are getting married, right? I think it becomes really kind of intriguing to analyze this as you think about the ways that a creative person might restrict who they are willing to work creatively for. And it's just a mess. You can see why they're trying to craft a rule that will apply. This is one of the things, Buck, that always happens.
They argued just on the interracial marriage point, this is important because this came up multiple times in the transcript. They said the law has recognized up to this point that religious objection to same-sex marriage is an area of religious liberty that has been established. It was even established in Obergefell. And the issue, obviously, the difference with interracial marriage is there's no respect for in the law, I should say. There's no carve out made for, well, you can be opposed to interracial marriage. So that was how they argued it today.
But to be fair, 60 years ago, they would have 100% allowed that carve out. So anyway, the way that you think about it is,
what I'm saying is they're going to try to get rid of the religious exemption carve out too. That's what I'm saying is happening.
Oh, I don't think there's any doubt. And what I would say is one of the challenges of a Supreme Court is, are you writing a case for law professors, or are you writing a case? This always comes up, Buck, when you are looking at what police can and cannot do. So many times the Supreme Court is trying to say, okay, well, officer who is on the street, you are able to do X or Y. Having an understandable rule that also can be applied is one of the biggest challenges that exist for complex cases such as these, because how do you know what the law actually is and what you're allowed to do and not do? And there's not an easy answer here, I think, although it's a fascinating case.